installation that was in Rockland for 10 months. So it's actually historical and milestone organization with the last people from 5 different disciplines coming together. And all kinds of issues came up that we really, as professors, did not know how to deal with, because the world where disciplines are specialized and other components with rules kind of set suddenly collapsed, and we found ourselves in a very hybrid space that was very much coming from very different angles of art and science. So John, being in the science world, did much more knowing than we did actually, because there's much more engineering involved, of course, and he came up with this idea to do this event, which I thought was actually fantastic. And the event is archived online for future access. When you do questions and answers, please use the mic. You want to say why you wanted to initiate this?
Yeah, sure. Yeah, so basically, although I am a professor in chemistry, I don't necessarily think they deal a lot with lawyers on average, but I came from 20 years at IBM where my position is kind of close regards intellectual property because I am just belonging to the corporation, okay? But I have worked a lot with like Andrew Neighbor, who's here, and Ken Palasco in the IP department because of the nanotechnology work we do. And a lot of the work is interdisciplinary, but it's still fairly clear to me who owns what, more or less, in the UCLA system. And then I started the project Nano, which was to bring together scientists, artists, fashion designers, architects, people from very diverse fields, and particularly from the arts and the sciences. What I quickly noticed was that there's a tremendous difference in how ownership is treated. In one case, you have a gallery atmosphere, you have, I guess, the deliverables are things in galleries and museums and so on, and you have artists who have a different sense of ownership than scientists. Essentially, my group, more or less, the intellectual property they produce belongs to the UCLA via me as a professor, okay? And this was not the case for art, and it became really mixed up in the sense that if we had scientific data that was transformed in some way into paper, it was quite clear the ownership. But if we take that scientific data and then we transfer that into artwork, the idea that it belonged to the scientist kind of vanishes and it becomes the domain of the artist. This was a conception that occurred, and as two people who were bringing together experimentally artists and scientists, it became a real headache, and we had to actually rely, even if you don't, we had to rely on Mark Nimmer, who is also a lawyer from Washington, to actually resolve some of the issues. And so this is how complex it got. So I thought it would be important that we have this talk, and I think it's very important it's streamed, because I think it's something that will be used in the future by many people, also outside the UCLA, to give them some frame of reference on what happens when you put art and science together, not only the positive things, but the legal issues. And it's something that's increasingly important, particularly in terms of funding from the NSF, where the education component and the connection to the public is becoming increasingly important. So scientists and artists will have to, just even to get the grant money, have to work closely together in the future. So that's why we had this talk, this meeting.
And we have a guest tomorrow that will actually give us some insight into the problem we have. So we're actually going to have 3 case studies, more case studies than what we had that will be addressed with Dr. Nimmer, who will be introduced by Nimmer from the Office of Intellectual Property.
Good evening. I'm Lorelei DeLana. I'm UCLA's Intellectual Property Manager in the Office of Intellectual Property Administration. We manage intellectual property that's owned by the university. So one of the things that we do often is moderate among campus personnel on ownership issues. Who owns intellectual property, which is something that's going to be a big discussion tonight. So, of course, when we're talking about intellectual property, we've got the copyright law, sometimes patent, and then we've got ownership, and then we have management. All kinds of interesting issues arise. So if anyone here ever has questions about ownership by the university or its personnel, always feel free to call our office, and we can help you out with that. So I wanted to be the person to introduce our guest speaker because I'm a huge fan. Any of you who deal with copyright law will know that Professor David Nimmer is actually the one who literally writes the book. He is the authoritative copyright attorney and professor. He writes a multi-volume that was begun by his father, and he continues it today. It is a volume that is owned by every lawyer who does any type of copyright law, as well as other types as well, and is often cited by the courts not just to talk about what the law is, but what the law should be. So in many cases, Professor Nimmer's treatise has actually influenced the law. He, as we are very fortunate, happens to be a professor at UCLA in addition to having a private practice at the prominent Los Angeles firm of Arella Manella. So we're really fortunate today. We thought who would be the best person to have come and talk about copyright law. Well, that's Professor Nimmer, so here he is.
Thank you so much, Laura. I forgot how I was supposed to speak. Thank you so much. It's a delight to be here today, primarily because we started, or at least in my case, I started preparing for this a good 12 to 15 minutes ago. When I saw these fascinating demonstrations that Victoria has put together, and I would like to waste no more of your time right now. I'd like to see it, and I'd like to react to it in front of all of you.
How do you turn the sound back on? All right, well, then you're going to if you don't mind. The first case study that I would like to present is actually a first collaboration. And just to give you a little bit of a background, in my work, I at one point got extremely fascinated by the work of Buckminster Fuller. But I was interested not only in his stone and architecture, but his philosophical systems that connected to structures and patterns found in nature. And through my fascination with his work, I actually discovered that the third carbon molecule, C60, was named after him. So I thought, how bizarre, Buckminster Fullerene. Why is that? Well, it turns out that Plato and Smalley, in particular, actually was fascinated by Buckminster Fuller's Expo 67 dome, the U.S. Pavilion in Montreal, and went back to the mathematics and the geometry of that dome to help him figure out the pattern of this molecule that they actually could not visualize at that point because the instruments in 1987 were not as strong as what they have today. So that's the name came, and that's my connection to the nanotechnology. Sometimes never expected to get there. Cut to 2001, I co-hosted a panel. There was very much a reaction to the development of the California Nanosystems Institute to see how it impacts the creative community on this campus. And the name of the panel was called From Metrics to Nanosystems. This is where I met Jim, who gave a first presentation of his work, which was very much working with Buckminster Fullerenes. And we immediately connected to the point where I was actually shocked that he didn't know who Buckminster Fuller was. And he was shocked that I was talking about the Buckyballs in such an idiotic way. So we had really both him trying to sell all those gaps for each other. And he thought it would be a good idea to do something together. I got an invitation to a major biennial in Australia of media arts, which is a new field that will allow us to become more like a director with software programmers and a group of people. So it gets very blurry who's in control even just on its own. You add science to that and you have another whole layer. There's a student, actually an undergraduate student, who did this piece that I we'll play without sound. Yep. And what you see here is it's a piece on the floor where when people walk, they throw their shadows, and they can actually manipulate their shadows through their movement. So what you're seeing here is that other students and faculty playing around with these shadows. And I thought, that would be really interesting. So I asked him if he would be interested to help us develop this piece, which basically, I can show you a video in a second. You manipulate the shadows with, the buckyballs with the shadows, but what I wanted to do is, instead of thinking small, actually blow up huge and have the idea of nanotechnology and access to this be very much in our world rather than something that's untouchable and far away. Now, one thing that I wanted to have Jim kind of take over here is, I think I have to go back. When I started talking to the students about doing this, we were wondering with the structure. And Jim ended up spending a lot of time working with him on this. He was on his STM where he started explaining. So people were very frustrated. And then here's his initial response, which absolutely irritated Jim. So I'll let him take it over from there.
That wasn't even an issue. So,
okay.
Okay, so I had done experiments basically where we used a tip to take this molecule, which is very small obviously, and deform it and bend it. And what I wanted to do was, and Victoria had this idea to use the shadow to manipulate the buckyball as a metaphor for the machine. So after explaining the structure of this buckyball, the initial result was something like a game, you know, where it bounces around, right? Just a spherical thing. And so we sat together and spent a lot of time, and where actually if we had done molecular mechanical calculations of how it deforms and to integrate that sense of deformation into it, which was integrated into it, so it's a scientific aspect. And also this type of motion here is a type of vibrational motion due to the thermal energy, and so we integrated that into the thing. And this slowly developed into this final result, and it was really the result of bringing the science and art together, where I could talk on a level to an artist, and the artist could understand on the scientific level. And that was more or less what we did using the question-oriented software engineer.
So, did you want to talk about the work you did to show how the difference, how it emerged?
Oh, no. I think I keep away from the science and we'll focus on
So this is the final result, and it's at the exhibition at Nano. And you can see there's a huge proportion and there's a big shift. Now, before I pass it on to Dr. Nimmer, I'd just like to say that the student, Vesna, actually went to New York for his graduate studies, and through a lot of PR, really felt left out, even though his credits were always there as a software artist. And at one point started showing the work, the software work, in other places without mentioning us, which we thought was not okay. And then at another point started writing these pretty nasty emails on the web, also how we somehow stole his work. Now we thought, okay, this is our university with our ideas, our concepts, and we paid him to do this. How is this possible? And this is where Mark Menick kind of helped us out by sending him a message, because when we tried explaining it in our own kind of logical way without any legalities, it didn't seem to quite work. It was a very, very emotional issue. And it's not to say that there's something wrong with his reaction, really. It's really about lack of understanding of how the process works, because in the end, he did do the software. He did do all the work, the physical work, even though it is software. But he also took the source code and destroyed it. So there's all these issues that came up that were really jarring to us, because we actually thought it would be nice to further develop the buckyballs and the bucky tubes and all kinds of things, and all of a sudden we were left with either we start from scratch or get another software developer and so on and so forth. Dr. Nimmer.
Can you put up on the screen the buckyballs?
Yes.
Great. Well, it's a fabulous exercise. Actually, yeah, good. Excellent. Let's keep that.
There you go.
We actually need to go back to 1789 to begin.
Because that's when the connection between copyright and science started. In fact, the framers of the U.S. Constitution said that Congress has the right to promote the progress of science and useful arts. Now, between science and useful arts, which one do you think applies to copyright and which applies to patents? What do you think?
Useful arts is copyright.
Useful arts is copyright and patents is science. A useful guess as of the year 2004, but it happens to be diametrically wrong as of the usage of the 18th century. Because science at that point meant something like you were being prescient or conscious. It meant knowledge. So science was the realm of the advancement of knowledge. And useful arts were things that could be patentable. So therefore, science is what copyright is, in essence, all about. Since 1789, of course, we've had a tremendous amount of progress since then. Copyright belongs to works that are fixed in a tangible medium of expression. So that's why a novel and a poem and a movie and the even a sculpture can be copyrightable, and a painting. Now, here we reach a wonderful conceptual issue. What is copyrightable here? Now, I'll talk about the easy things first. There's an audiovisual work. There's a movie, if you will. It doesn't happen to be fixed in celluloid. Instead, it's fixed on a computer hard drive, but that's fine. We have an audiovisual work. So the fellow standing out in front, putting his arms up, casting a shadow with the things in back, that's an audiovisual work. In addition, we have software that I presume created the image in the background, if my guess is correct. Okay, that software can be copyrightable, and we'll get to that in a moment. But I want to focus right now on whether the buckyballs manipulated are copyrightable, because I think that's what you're interested in. In other words, can we forestall the Museum of Modern Art in New York City from coming up and saying, oh, you know what, I was just at LACMA, and I had this great idea, I'm going to hire some software engineers to do something on a crash basis, and now we're all invited to downtown Manhattan to see a manipulation of buckyballs. Now, will that create an act of copyright infringement? Well, if they copied your audiovisual work, that would be infringement, but they're not going to. They're not going to have this fellow here from that angle over from the right. If they copied your software, if they got a hold from Mr. Nimmer of the various modules and the algorithms, and they just duplicated exactly, okay, that would be infringement as well. But I'm going to presume they're not going to do that. So the pure issue is framed, do we have protection for these buckyballs? Now I'd like to talk about the World Series, which just ended. What about a baseball game? Is a baseball game copyrightable? Well, again, we can have the same issues. First of all, there can be the ABC telecast of the World Series, and that's copyrightable. So if you copy the precise angles that the cameraman used and the way that they cut, okay, that's copyrightable. But is there a copyright in the choreographic work, if you will, of the baseball game? Well, as with most things in law, the answer is confused. The answer is either yes or no. I personally believe that the answer is no, but what do I know? The Court of Appeals in Chicago has held that the answer is yes. However, every other court in the country has disagreed with them. So that's a good introduction to this very realm we have, because probably if we litigated it, we would get the answer yes in one court, and we get the answer no in another court. So instead of leaving you going with indeterminacy, let me give you my own view. Copyright exists in a work fixed in a tangible medium of expression. Now, if I understand correctly, by him raising his arms, he's manipulating where the image falls. So it's not fixed in a tangible medium of expression ab initio. Rather, it's a function of his being there. Now, the law has actually confronted this particular question in copyright cases. Anyone want to guess when and where? Could be anywhere from 1789 to the present. Give me a wild guess where you think it might have confronted this issue. Performance art. Okay, good guess. It's not what I'm thinking of, but it's a good guess. We got an error, by the way. Just throw out a year. Could be 1910. That's the 1930s, okay? Or Stravinsky's Rite of Spring, okay? Any other guess? Well, it happened in 1982, and the subject was video games. Because you know what? When people are playing Pong, which was what was litigated at the time, the little thing is going up in this direction or that direction, depending on the user turning the button. So it's not really fixed in a tangible medium expression. And then when you get those warriors fighting each other, every single time the game unfolds, it does so differently. And so, of course, the defendants put on an expert to testify that there are 172 quadrillion different possibilities of playing this little game of Mortal Kombat. So it was not fixed in a tangible medium expression. It happened, it ended, it was an epiphenomenon, so that's not copyrightable. Well, the defendant lost. The plaintiff who put out that video game won, and it did so on the following basis. By saying there is an attract mode that is constant. In other words, when you're standing away from the console and you're looking over, oh, look at that game Pong, look at that game Mortal Kombat. It always runs through the same 45 seconds to try to tease your interest. And that 45 seconds was stored in the hard drive, so therefore it was stored in the tangible medium of expression. It would recur the exact same way every single time. And it was based on that the court was able to say, I rule for the plaintiff. There is copyright protection here. So if you had come to me before the exhibit was put on, I would say, look, let's have an attract mode first. Let's store 45 seconds of the buckyballs doing the same thing that will happen every single time. And based on that, we will claim that we have copyrighted it. Now, if you had come to me in the middle of the exhibition and you had not done that attract mode, I would say, let's set up a camera and let's take 20 minutes, or probably take 3 hours, of shots of the balls moving around, and we'll hope that we will capture a whole variety of poses. And we'll hope that the people of the Museum of Modern Art happen to do things that are similar to the poses that we found, and we'll go against them based on a kind of motion picture theory like that. Just like if my client Disney owns Snow White and you put on a bunch of dwarfs with a black-haired lady that you call whatever you want, I'd say, look, okay, it might not be exactly like Snow White and the Seven Dwarfs, but you know what, it's close enough. But getting down to the basic issue, do you have a copyright in your buckyball presentation? I'd have to say no. I don't think that you have created a new work of expression fixed in a tangible medium of expression that can stop somebody from going ahead, re-engineering it in New York and putting on their own rival exhibition. So that would be my quick answer to this. Now, you could hire somebody else to come in on the other side and disagree with me, and that's what lawyers are all about and laws are all about. But let's talk about credit. What about the dastardly fact that somebody went on the road and did not give credit? Well, by the way, everything that you're saying about this scenario, I've confronted in the business world time after time. I've confronted people who develop software who then have destroyed the source code, who have left employer number one, established business number two, employer number one sues business number two, and vice versa, and then they sue back. Credit's given, credit's not given. These things they happen all the time. So let's talk about that realm of credit. Okay, I now need to go to a short digression into World War II. Dwight Eisenhower wrote a book called Crusade in Europe. He published it with Doubleday, and the Fox company in 1950 decided they would make a mini-series about this. So they called the mini-series Crusade in Europe. And they put together 12 hours and had a nice little documentary that they put on TV. Fox forgot to renew the copyright. So 28 years later, that audiovisual work went into the public domain. Along comes a company named Daystar. And for 1995, it's the 50th anniversary of World War II, and they say, wouldn't it be great to get that thing that we saw when we were little boys and put it on videotape and sell it at Walmart? And so they did it. They went and got that original show from the 1950s, which was public domain. It was not protected by copyright. And they repackaged it, and they gave it their own new name, and they said, Daystar presents World War II, campaigns in Europe. Along comes Fox and says, how dare you present our material? And Daystar says, it's not your material, it belongs to everyone. It's no more your material than Homer is your material. It's true you might have written it 50 years ago, but you don't own a copyright in it. And Fox said, yes, but you took our name off. You said Daystar presents. You should have said Fox presents. Now that was completely disingenuous. If they had said Fox presents, if Daystar had put together a package and said Fox presents, then Fox would have said, how dare you use our name? That's passing off. We're going to sue you. And there's not a doubt in the world about that. But Fox said, how dare you take our name off? That's reverse passing off. And they went to trial. They won. They went to the Court of Appeals. They won again. And at that point, Daystar did something different. They hired me and a team of other lawyers, and we took a swing at it. We went to apply to the U.S. Supreme Court. And to our surprise, the U.S. Supreme Court said, yes, we want to hear this case. So we duly flew off to Washington, D.C. in May of 2003, and we're very pleased when we won unanimously some months later. So the U.S. Supreme Court said, look, just because something was originated by Fox, actually, I'll tell you what Justice Scalia said during oral argument. He said, look, if I invented the vice grip and I don't have any protection in it, does that mean I can stop you, that Mr. Vice Grip can stop you from selling it and you have to call it Scalia's grip? No, call it anything you want as long as you're not fooling the public. And that's basically what the U.S. Supreme Court said. That as long as nobody was being fooled when they got Daystar Presents Crusade in Europe, then it doesn't matter. Consumers were not being ripped off. And Fox does not have the right to say, mine, always mine, I created it all those years ago, and you always have to use my name. So my sad answer to the second part of your inquiry is, you really could not require Josh to use your name, and you could not stop him from using his name in the commercial marketplace. Now, I have an article coming out about this, so I want to hasten to add the following. Don't try this at home. At least if your home is UCLA. In the academic environment, there's no more heinous offense than plagiarism. You can't simply take something that's 29 years old and say, you know what, I'm going to scratch out the author's name and turn it in as a paper and put my name on it, because that is an academic offense. But in the business world, you're perfectly allowed to do that, as the Daystar case for the U.S. Supreme Court establishes. So there are some of the answers to get us going, and let's either ask more questions about this or get into the second scenario.
I just have one more question before I pass it on that actually goes very well with your last statement. Let's say, hypothetically, that MoMA, who you mentioned, comes to me and says, I want to buy this piece. We want to buy it. We want to own it. It was produced on the university grounds with university equipment by university students, conceptualized by two faculty. How would you do that?
Well, we would ask Lorelei. We'd have to look at the university policy, and every university is somewhat different. For instance, in the law school, when a professor writes an article and it goes into the Stanford Law Review, UCLA does not pretend to own the copyright to that article. Now, it doesn't matter much because it's not a very commercially valuable function. On the other hand, the University of Florida does own Gatorade and gets $50 million every 25 minutes from it, but that's a matter of patent law. Copyright law protects a work of expression, which is an intangible. That's why it's known as intellectual property. Copyright law does not protect this particular physical installation. So your question, I take it, is, what if they want to buy the actual physical products that we put together? That's not a question of copyright law. It's a question of the tangible property. It's also a question of your relationship with the university and what type of clearance you need from your dean, from the school, from the Office of Intellectual Property. So we have the relevant actors here, so they're welcome to come up and address that. But that's not my field. But maybe we should.
I just have a question. So in that case, rather than, let us say we have something like this and then I send it to Ken Velasco and write it in such a way that it would be an invention disclosure.
in that case, then, if it was a patent was applied for it, or at least over the period of a year before we got the patent, it would then belong to UCLA and the person who wrote the patent. Can you also patent of the things you could patent everything that you can copyright, or is
No, copyright applies to works of expression, a movie and a book and a sculpture. Copyright applies to that. Patent applies to useful items. So it could be something like a cheese slicer on a marble slab with a wire, which is an actual patent, or it could be a piece of a transistor, and it could be even a business method these days. But ideas are not copyrightable. Ideas are free as air in terms of copyright. But ideas could be patentable if they're non-obvious and novel. And
is a game then defined as something that's useful or something that's...
A game is not copyrightable. The rules of a game are not copyrightable. And that leads us into all sorts of other domains. I'm not a patent lawyer, so I don't want to...
No, I have, from my angle, always assumed that anything that would be artistic would be subject to the same kind of procedure. I could write a disclosure and send it out, and it would be protected in the same way as an invention.
Another thing I want to mention is patents require a long process of applying to the government in order to get a patent. You have nothing until you've prosecuted your claim and met with an examiner, and finally you get a piece of paper that says you now have a patent. Copyright is completely different. When my 9-year-old is at home with a bunch of crayons and finishes up after 5 minutes, she has a federal statutory copyright in the product. It has not been registered, but there is a copyright in it because it has been fixed in a tangible medium of expression. In fact, Congress took note of that when it made an exception from moral rights of artists so that kindergarten teachers don't get sued at the end of the day for cleaning up the class, because technically those are all works of art. So they said it is going to be a tort as of 1990 to destroy a work of recognized art. So as much as I love my 9-year-old, she's not a recognized artist.
Let me add a couple of points about ownership. Laura said it well when she said that often our office is involved in figuring out who owns what. Under policy, the original intellectual property policy of the university was a patent-only policy and related to inventions, which I think in the art are defined as effectively, it's synonymous with patentable. It's something that has utility and is new and unique. So our policy really built off of the fact that we were doing research at the institution and that we might create inventions. And at that time, when that policy was introduced, I think the university, like most academic institutions, simply believed that any other works, copyrightable or not, would be any works produced by its faculty or students. So that could include books, papers, paintings, films, etc., would be the property of the creator. In 1999, 2000, we established a change in that policy which said that if the work was produced as part of the research enterprise, and effectively that meant that if the work was defined as a deliverable under a sponsored research project, then the university had the right to assert ownership in that product. Some of those products will be copyrightable and some could even be patentable, particularly of the software variety. And we often look at certain pieces of software developed in the research lab and because of their patentability argue that they fall under the patent policy. But if a sponsor says to a faculty member, we need you to develop a new protocol for treating a patient with a drug, that written protocol, which would be copyrightable in its tangible form, is a copyright that the university could claim.
And what if 4 undergraduates helped the professor to put that protocol together?
If they were using the funds of the drug company under the sponsored research, then it would belong to the university. And it's a bit on the students, because if they're graduate students, they're on payroll, therefore they are employees of the state. If they're undergraduates, then the university has no such claim over their rights.
Okay, that's very interesting.
And so it would be a shared ownership between the university and those students. But typically we won't put undergraduates on a funded research project for that reason. Typically it's graduate students, faculty and staff that would be creating intellectual property owned by the regents.
Well, there's a vast literature about who owns copyright, the professor of the university. It's literature that's written by professors, and most of it concludes that the professor should own it, but that doesn't happen to be the law. You can also read, for some graduate students writing complaints, that we are the leper class of academia because we get nothing, which I think is true. And I've never seen a case involving an undergraduate, except for plagiarism, and an undergraduate is brought up on plagiarism charges. I've never seen a case in which an undergraduate claims to own a copyright or a piece of a patent.
I think it's important to add why the university made this change. It isn't because the university wants to extend its intellectual property assets and take over and own all of the future works of art. What it's essentially concerned about is, would the sponsor who is supporting the research assert some right against the university at some point in the future, claiming that because they funded that research, then all the results of that research belong to them, copyrightable or not, patentable or not. And many of our research agreements are written in a fairly broad way, relating to the results of the research, the inventions arising from the research, data, information, ideas. So we need to make sure in a research environment that those rights are clearly ascribed. But we clearly say in the policy that we will encourage and support our faculty to own and dispose of their own copyrightable works that are created as part of their teaching or their creative activity or anything of that nature. So research is the important word in a way.
Very quick question. Excuse me, back to the remote control of buckyballs. Is there nothing that we can do to monetize the value, the contribution of the person who made it possible to make that buckyball up on the screen change its shape in a certain defined way? It's not willy-nilly. It doesn't just happen because it wants to. The person in the audience does something that makes something happen predictably, and someone has created this valuable capability. How can we monetize that if it's not copyrightable, and if it's not patentable, what then is it?
It's not copyrightable. Whether it's patentable or not, I don't know. We could have another session calling a patent lawyer. Do you have an opinion?
Well, it would seem to me that's a bit like Photoshop. I mean, you have a tool which, albeit is built on scientific data that Jim developed, but he's created software that behaves in a certain predictable way after somebody in the public influences it. So whether it's Photoshop or Painter or any number of computer software that artists use to create their works on the computer, they're doing the same thing. Now, the packaged Photoshop CS, which you buy for $299 academic, they get a piece of that because it's copyrighted. But they don't get a piece of what you create with that, and the artist gets that.
Good. That's a very helpful intervention. The trick here would be for the inventors to say, look, we took 5 ingredients that had never appeared in conjunction. And that's great, they might get a patent. Of course, that would only stop somebody from practicing those 5 ingredients together. It would not stop somebody from doing 4 of them. So there's a dance there that gets us deep in the patent law.
One usually, I mean, from my understanding, if I was to write a disclosure on it, I would say 4 ingredients or possibly 5 ingredients and give examples of more than the 4 ingredients, which would cover somebody else changing the ingredients. That's the way I understand it from working in IBM. You get around it, you see.
Shall we go to our next? Good.
Okay. Okay, so actually one of the people that worked on this, Andrew Pelling, graduate student who's a scientist, he's here, and actually the person he works on with the art project, Anne, is listening. And this is interesting in a sense. This is some research that I was interested in even before I joined UCLA, and it was to record the motion of cells with a specific scientific embodiment. And we were able to do that, which was scientifically very interesting, okay? And in the process of doing that, at the time working with Victoria, I asked Andrew if he could make a sound file, which I sent her, and it became interesting in the sense that we started to use sound as a medium that I would not normally think of using for this scientific data, okay? But it was actually very interesting. And it started to become an art piece which was incorporated into the nano exhibit, right? Now this research is actually funded by NASA as scientific research. And there is a patent on the scientific invention of this recording of the cell cells. But in the process of that, this piece then was used, this music that resulted from this was used by a Swedish radio interviewer who produced a piece of music, okay, which was then broadcast on Swedish radio and is on the web. Can you play the music? And Andrew will, he could play it for you. Can you play? Is it possible? I think it's live. You can go ahead. Okay, the piece was then used in Vesna, and then the piece also, this sound aspect of the research became quite dominant in the sense that the front cover of LA Weekly, which is a big magazine here, was, you know, just covered over to the screaming cells. And then Andrew and Anne set up an independent piece called Cell Sounds, okay? So we had, and Anne was a graduate student who worked with her. And then later the scientific paper appeared in Science, okay, which stimulated a lot of interest. And recently a movie company asked if they could purchase the sound for use in a horror movie, the Cursa El Choro or something. And I told them I don't want that anything to do with money, but you know, so because it was too complicated. So now the question is, who owns the sound? The sound is a unique, it's a nanoscale motion, okay, and it's and that's a whole issue we have, you know, and how do we deal with that?
Yeah, let's hear the sound.
Oh, you have to install it. In the Smithsonian, and things have been so bad actually that yesterday I got an email from a woman who is dying from a brain tumor who has offered me a piece of her brain so that we can, you know, record the motion. So and we also had the Maharishi Yoga write to me who was interested in. So it's a kind of piece of science and art or whatever that is somehow hitting upon everybody's interest. These are some of the sounds. That was dead. And, well, I don't know if this is one more song.
So before we pass it on to you, I think, to me personally, what was interesting about this case is that scientific research, which was relegated most of the time to science labs, was transferred into sound, which, because of my context, I interpreted as a composition. And that changed his perception, Jim's perception, of the work he was doing. It stopped being strictly scientific data, and the idea of the scientist being equally creative to an artist was very much present. It wasn't simply taking the data, because arriving to that data is the creative process. And one of the things that we did in Nano is insist on that, to great resistance on many occasions from the arts world, that scientific data doesn't necessarily mean it's segregated into facts and data that's come out of the lab, but it actually is a result of a very creative process. And what the artist does is he or she frames it in a way that takes that into a creative context, but that doesn't mean that the process that arrived to the data was not creative. So it became this very blurry territory where the tension that we wanted to address arose when Nimmer, who's my student, one of my best students who recently graduated, worked on the Nano project, and Andrew, who's one of the best Gym students, also worked. They came together. We were incredibly proud of this and came up with a piece that we were also incredibly proud of. But I noticed a kind of a tension happening, particularly between the scientists, where at one point Jim was feeling, well, wait a second, that's my creative work that you guys are just using and kind of reframing, and how do I fit into this? And we didn't really have any clear answer, and I can't say that it was actually quite resolved. And personally, I think this will happen more and more as the barriers become more fluid and open. So how do you address this problem?
You might have heard some years back there was a company that was taking the product of everyone else's music and offering it without paying any royalties to the original inventors of the music. You know what the name of that company was? Napster? No, I'm thinking of the Aeolian Company in 1905. They put out something called piano rolls, and it would play Swanee River or whatever you wanted, and they said, look, you know what? The Copyright Act protects copies, and copies have been the courts have told us are works that are visually perceptible, and you can't tell what the music is by looking at these little holes in the piano roll. And the Supreme Court in 1908 agreed with them and said, that's right, this is not copyright infringement to put out piano rolls of everyone's music. So the fear was the great music monopoly was going to arise, and Congress made our laws very complicated in 1909 as a result, and it said, you know what, we're going to put something called the mechanical compulsory license. And that means as soon as a composer puts out a song, anyone can make their own version of that song as long as they pay 2 cents per record that's sold. And that's stayed a part of our law until this very day. It's risen precipitously from 1909 till 2004. It's now 11 cents per record sold. So that means if Eminem puts out a record that you buy today, you can get into your studio, you can sing and imitate Eminem's voice, you can hire even his backup musicians and put out your own cover version and just pay 11 cents per record sold. Now, I belabor this to say that copyright law is built on various distinctions. You could not do anything like that with Philip Roth's novels. You can't say, I'm going to kind of hire somebody to come into a lab and write about a mother and a son, but it'll be different. Absolutely not. So musical works are treated completely different from other works, and there are special rules for audiovisual works and on and on and on. Now, if we treat this composition as a musical work, anyone can do their own cover of it. On the other hand, if we treat it as a different type of work, then nobody can do their own cover, and you can strictly control the reproduction of it. Now, it occurred to me somewhere around 1990 when Nimmer on Copyright first came out on CD-ROMs that those distinctions are breaking down. If this CD-ROM, this little piece of silicon, is viewed as a literary work like Philip Roth's, then it's sacrosanct. On the other hand, if it's viewed like a musical work, then anyone can do their own cover version of it. And you know what? A CD-ROM to a computer is the same thing as an audio CD, meaning that some of our fundamental distinctions are breaking down. What do we do with this? Well, you can, first of all, I need to now cross-examine the creator. So who wants to get up? Should I have you bring Andrew up here? Or, okay, yeah, okay. Come on up. I want to ask you some questions. Okay. Okay. You're going to tell me the truth, aren't you, Andrew?
Probably.
Okay. Now, tell me about that music.
Okay.
If, let's say we didn't have Victorian Jim here, but instead we got Allison and Bill, would they have come up with music that sounds the same from the cell?
The composition
Yes.
that's up there? Probably not, no.
How different would it be?
I'm sure it would be as different as they are from me.
Okay. Would you say that this composition is subjective?
Yeah, I think so.
And whose subjectivity is it a product of? Yours? Jim's? Victoria's? Combination?
Well, how far do you want to go back? I mean, you know...
Your mother?
Jim...
Tell us about your mother.
And then Ann and I working together influence each other, and then, you know, and Victoria and Jim obviously influence us and the people around us, so...
Okay.
Stage one, I would say Ann and I. It's subjective to Ann and I.
Let's play the composition
Sure.
again, okay? Now, if we had your worst enemy coming in here and wanting to put together a composition that sounded as differently as possible, but based on the same cellular movement, how different would it sound from this?
I have no idea.
Just on a purely scientific level, if the machine is operated in the correct way, okay, the sound would be somewhat the same based on the fact that we did these experiments where the data is reproducible.
So the tempo
wouldn't be exact. Yeah, the tempo would be the same. The tempo is dependent on the temperature, so it would be the same as it provided at the same temperatures used.
And
so in the sense of subjectivity, we are as scientists trying to be objective. So the sounds are an attempt to have an objective. An objectivity in the, we're trying to record it as faithfully as possible. It's not a musical instrument.
Yeah, okay. Anything else occur to you about this?
Well, yeah, well, I mean, what Jim was saying, I mean, if someone had come along and recorded at 30.5 degrees or some other temperature, we haven't recorded it exactly at 30.5 degrees and 0.6.
We hope, I think we could say that because we published the paper
Okay.
I think we can say that because we published the paper in Science, right, and it's based on these this sound, okay, we would hope that it would be identically reproducible by other scientists in the world. You see?
Okay. Well.
And if it's not, then that is not a good sign. You see?
Okay.
If you were to take this as a note, it's longer and it has more variability than a note. But take this as a chord, for example. Then the question is, the movie producer wants to use this to make a horror movie, so what combination of these notes or chords would make the most horrific sound? Don't you then open up a different set of questions with perhaps different answers?
Okay, I'm going to now try to act as a copyright lawyer and answer these questions. It's very, very difficult. I want to distinguish between two types of copyrightable works that we have not focused on. Musical compositions and sound recordings. So to go back 50 years, Cole Porter would write the song The Lovely, like if you just saw the movie recently, and Frank Sinatra or Bing Crosby would sing it. So there's one copyright in the music that Cole Porter composed, and there's a separate copyright in Nelson Riddle and his orchestra getting together with Frank Sinatra singing it. So ASCAP owns the one copyright, and Atlantic Records owns the second copyright. So now let's ask the question, is this composition as musical composition or as a sound recording copyrightable? As a sound recording, it's fairly straightforward to tell you, yes, it is copyrightable. You could get out, you could put a microphone out your window at 2 o'clock in the morning and cats happen to walk by and the garbage truck is clanking, that's a sound recording. And the tiger walks by, depending on where you live. So that is a copyrightable sound recording. So I don't have much hesitation in saying you have produced a copyrightable sound recording. That's something that protects only the recapture of this sound. And in fact, when Bette Midler sings "Do You Want to Dance," it's perfectly legitimate to hire somebody and say, "It's uncanny, you sound exactly like Bette, and I'm going to hire her backup musicians," and you might produce something that Bette's mother would say, "What are you doing over there? I thought you were in the living room." But that's ethically legitimate. That does not violate copyright. So you would have a copyright against sound recapture, but not against sound imitation on your sound recording. Now, as a musical composition, I'm going to talk about a recent case. Anybody know James Newton, a flautist who produced a work well, there's an album called James Newton in Venice. He is famous for overtones. He can play the flute, and you hear 3 different notes, like a high C, middle G, low A. So it's a very distinctive technique. So distinctive that the Beastie Boys copied it exactly and looped it throughout their entire song. Now, the Beastie Boys had permission from the record company, but they did not have permission from the composer. It so happened that James Newton was both, but that's just a sideline. So James Newton said, I'm the composer, you have copied my work. Went to Judge Nora Minella downtown in LA. She said, no, these 3 notes, it's 4 notes, but one of them is repeated twice, it's really 3 notes, do not make a distinctive composition. Went up to the Ninth Circuit Court of Appeals and they affirmed. Copyright almost always exists in melody rather than in tempo or harmony, because it gets very, very dangerous to say, yeah, you have a copyright in the tempo, and so, James Brown's going to shut down everyone who, comes within 500 feet of him. You have a copyright in the melody. I don't wish to give any offense, but I did not find this composition to be terribly melodic. And so I would conclude that there is no copyright in the melody here. Now, in addition, I want to go further. I was hoping to hear something that sounded like John Cage when the cells were pulsating, and it wasn't quite that melodious. But let's go to John Cage for a moment. Let's say that this did produce some weird, not Schoenbergian 12-tone, but some 37-tone thing that was just going all over the place. Now the question would become, do you have a copyright in that? And I just can't resist talking about a fellow in England who just put out an avant-garde recording. And at the end of it, he had silence. And so he said, this is 2 minutes of silence after John Cage's 8 minutes and 33 seconds of silence. So naturally, the copyright owner of that said, well, how can you copyright infringement? You don't get a license to copyright silence. So what are you talking about? This is a digital album. This is digital pirates. You just have analog So let's imagine for a moment that you did generate musical tones in a kind of weird progression. That would be a tremendously stimulating copyright case. It would be like, if you don't mind me drawing a weird analogy, the case of the Dead Sea Scrolls that was litigated to the Supreme Court of Israel, in which a paleographer, an archaeologist, decipherer of ancient writing, put together various shards found in Cave 4 of Qumran to make a document called 4QMMT. And along comes Herschel Shanks and publishes 120 lines of a reconstruction of the text of 4QMMT without permission. And Cameron says, I've spent my life on it. I put these together, and it required great expertise for me to put it together. And Shanks, in defense, said, look, all we're trying to do was put it together the way the original person had it. This is not, now, not being that you're the greatest archaeologist, you have great skills in paleography and in ancient halacha and in knowledge of the Babylonian Talmud, and you might have done a better job than anyone else. But in essence, you were not trying to create an individual work of expression. In fact, it would be slanderous if someone were to come along and say, Professor Kimmerer, I loved your imagery. It was just beautiful the way you combine those things. Well, where did you ever get that idea? He said, I don't know where I get that idea. I was just putting it together when it was written 2,000 years ago. How dare you say that? So he was not trying to do something subjective. Now, it so happened that case was a very bizarre case, and if you ever have an extra 4 hours, I'm happy to come back and talk about it. So Kimmerer won the case and Shanks lost. But I happen to think that the defendant Shanks should have won the case on the precise issue that we're focusing on now. Now, that's why I asked Andrew, was he trying to be subjective? And I'm not sure, if I was coaching him for deposition, I'd have to take a good deal of longer time with him, depending on which side they were on. He was a bit, it was a little subjective, but it wasn't that subjective. So I'd say that to the extent that you have created a mechanism of recording in a non-subjective way cell vibration, whatever that means that I just said, then you don't have a copyright in it. So even if it were somewhat melodious, or even if it did have different tones, it would be a very tough case, and courts could go either way on it. My own personal view is that would not attract copyright protection. But we're not only at the edge of copyright law, we are way beyond the edge. We have fallen into the great abyss now. Somebody just turn the microphone.
It seems to me that from what Jim said, the reproducibility of this makes this sound, in essence, rather like plucking a guitar string that's been set at a particular tension, for example, and it produces a note. Now, if Andrew and Anne had taken a series of recordings of different notes or different reproducible sounds and created that melody, then they would have created a tune which could, in essence, be copyrighted. So I just suggest they go back to the recording studio and get to it.
Okay, that's a very good point. And you want to come up to get the next one ready, Victoria? Yeah, that's a very good point. If the lab decided, you know what, here would be a great artistic product. Let's start with an amoeba at 30 degrees, and after 15 seconds we'll go to a multi-celled animal, at 80 degrees. Okay, that would be copyrightable.
I just want to say something though, from my point of view of the art, that if we took the cell tune sounds and made a tune out of it, it would be not art to me anymore, because it would be, just making a tune out. It would be like, it would lose this cutting edge element of which is not defining art, defining music according to what lawyers think music is, because must be the end of music, surely. Do you follow me? If a lawyer said, we're going to make a music to appeal to the lawyers, then it can no longer be music.
Did you want to say?
Yeah, I think, well, whether it's art or not is not, I don't think that's even an issue, right? You can call it whatever you want. But I think, it's sort of similar to if I buy a guitar from Yamaha or whoever, do they then own, rights to whatever thing that comes out that I record in the end or put together? Now, the raw sound, obviously there's UCLA and Jim involved there, and I don't think there's any issue with that really, but to take, the other issue, I guess, is that I'm not as disadvantaged as many other graduate students, because Jim's been very gracious, so I own some intellectual property here. So then if I go and I take, this to my guitar and I create a sound or a recording, then it is kind of like what was pointed out just now, that isn't that a copyrightable piece at the end when you put these things together? And that's what I was meaning by subjective, the way we took the science. So if Victoria and Anne had this set of sound files and Jim and I had this set of sound files, and Jim and I went off into a room and put them together, and Victoria and Anne put them together, and they would come out completely different.
Mm-hmm. Yeah, do you want?
I'm kind of amazed that you said anybody can take any song, reproduce it.
Sound imitation.
Sound imitation.
Right.
And all they have to do is pay 11 cents per record. What if they don't sell a record? They post it on the internet for free.
Well, the internet, of course, is a challenge of its own. There's a thing called digital phonorecord delivery, and that has a separate schedule as opposed to the 11 cents for selling a vinyl or a CD-ROM. So there is a tariff for digital phonorecord delivery if that's what they do. Now, if they're fostering wide-scale reproduction of it through the internet and not engaging in digital phonorecord delivery, they might be culpable of copyright infringement on a different theory.
But they're not profiting from it. They're just posting it on.
Yeah, it doesn't matter. We'd have to examine exactly what they're doing, and that would get us into a very, very complex field.
And the other question from an earlier example you gave about Fox, they pulled something from the archive that's no longer, and now it's in public domain. Now, is the new person obligated to say that this was a fox and put it in the credit somewhere?
Okay, that's a good question. It's a matter of consumer confusion. So if Daystar said, all new material never before seen by World War II crusade in Europe, okay, that would be a false statement, so that would be false advertising. If it was something incredibly well-known that people are likely to have seen, and then they buy it and they say, what is this? It's been repackaged. I didn't want this junk. I thought I was getting something new. You might be able to put together a false advertising claim. Those are not the facts here. People did not have this 50-year-old Fox thing on their mind, so the Supreme Court went out of its way to say there's no consumer confusion here. People don't care if it says Daystar Presents or if it says something else. And in Hollywood itself, produced by, which was Daystar's credit, can mean anything from the producer's bodyguard to the investor's wife, because anybody can get a produced by credit.
But are they obligated to say it was a fox from the...
No, they're not obligated to. In fact, Justice Kennedy in oral argument said, who cares about those credits that roll when everyone's either going to the kitchen or reading a cert petition, which is what he does, reading certiorari petitions. It gives you an idea of where the Supreme Court justices' minds are at, and they're the ones who decide about consumer confusion. Should we go on? Oh, there's one more question.
Well, we had a situation in my past job that might be very similar to this, and I'm kind of curious as to where you draw the line, because I used to work at MIT, and we had a satellite that would listen to X-ray sources from distant black holes. And we plotted that data and eventually made sound files out of those plots. The numbers in the actual data file that shows the deviation or whatever, that's public knowledge. That's something we posted out there. The actual mapping of that to a sound file basically had to do with where we decided to put middle C in terms of in relation to the actual curvature, and then we created the sound file. You said that it was that you had a copyright on the recording. Where does the copyright happen?
Well, let me talk about a compilation copyright as well. There's a case that went to the Supreme Court in 1991 about the white pages of a phone book. Somebody meticulously put together the name of everyone in the locality in Kansas in alphabetical order, and along came another company and copied that, exactly. In fact, they even copied the 7 trap names that were fictitious listings that were put in to detect copying. So they just copied the whole thing. Went to the U.S. Supreme Court. The U.S. Supreme Court unanimously said, that's not copyright infringement. You don't have a copyright in the facts that all these people live in a certain locality in Kansas. However, if you were to imbue your own selection and arrangement into it, you could have facts. So if you want to make Bob's 100 best friends in Lawrence, Kansas, in the order of their congeniality, okay, you could have a copyright in that. Or you could make your list of favorite Chinese restaurants, and you could have a copyright in that. I think it would not be difficult for you to take all of that public domain data out of MIT and to put it in an order of your own choosing and to say, we have a compilation copyright in this particular selection and arrangement. But you could only stop somebody from copying that selection and arrangement. You couldn't stop them from saying, what a great idea, getting the original tapes from MIT, assuming they have access to them lawfully, and putting together their own version of 20 minutes of musical delight. Does that answer your question?
Yeah, I'm not clear because I was more curious as to, you said that the recording, like if you hung a mic out your window, you would have a copyright on the recording, and it was just particular to that specific recording. So if I were to say, take the same exact data file and use the same exact methods, but for instance, reduce or increase the number of entries in it, or change the location of middle C, so you create a different sound. Is that a copyright violation?
Well, it would not be a copyright violation because you're not violating anybody's copyright. I think your question is, would you have a copyright in what you put together?
I think the question...
Get the microphone, yeah.
No, I think the question is, you see, if we have scientific data, and it's just numbers in a computer, and you represent that data in a different length scale or a different frequency scale as a sound,
what we're dealing with, because then you produce the sound that you record, okay? And there could be many, many different sounds, because you could use many different, you could convert it into many different frequencies and many different sounds. So is the data copyright? There's a data copyright, and then there's a copyright of the music you make from transferring that data into whatever it would be. So what is copyright? In other words, if I make a nice picture of scientific data, is the data copyright and the picture copyright, or what's the deal? Is that what it is?
Yeah, it's an excellent question. Copyright does not protect data. That case I mentioned about the white pages said facts are uncopyrightable, so data, of course, are facts. So the data themselves are uncopyrightable. You have an excellent way of putting it, that you're generating kind of musical work based on that data. Let's put it this way. A lot of money is being spent by LexisNexis to lobby Congress to pass a new law that gives protection to data. Now, you could go, maybe you could make your fortune by flying to Washington, D.C. and say, you know what, you don't worry about getting a new law, just put out musical compositions based on all that data that you've collected. The problem is I don't think we'll find consumer satisfaction in terms of listening to that music. Although clearly if you had a converter on the other side taking the music and putting it back into data, you know, that sounds like there is some possibility there. I don't have a very satisfactory answer except to say that nobody's even tried to come close to getting a copyright in a representation of data as a musical staff form.
But what about a human genome? That's data, right?
Right, and the human genome is not copyrightable. Actually, people have come to me with bizarre ways to talk about that as a compilation, especially if they do it themselves. That gets us very, very complicated. I see our time is running, so let's go to the next demonstration.
So the next case is actually quite different and brought up, again, a number of different issues. It's called the nano mandala. When we worked with LACMA, one of their big issues was because we were in LACMA West, which is kind of the experimental wing, and the main building is LACMA East. They were very eager to somehow connect LACMA West and LACMA East, and they kept asking, which piece would you like to bring from LACMA East into the show? So they kept sending me to the contemporary art section and looking at, there was nothing that remotely connected to nano and what we were trying to do. And so in our discussion, many times, Jim would actually talk about, he has to leave early, by the way, this is why this testing's happening. He was talking a lot about the idea of the scanning tunneling microscope and this enormous machine actually constructed to create a state of nothingness. So at one point I thought it would be interesting to actually connect to the Southeast Asian department in the museum as opposed to the contemporary, because they dealt with these kind of issues. As it happened, there was a show that was happening in parallel to ours for the first couple of months of Nepalese and Tibetan Buddhist art. And I heard that they were bringing Tibetan monks to create this absolutely amazing mandala that's 7 foot in diameter, the largest one ever constructed in the States. And in our discussion, we very much came up with the idea that it is really connected to the idea of nanotechnology in the sense that they start with one grain of sand and then go into this incredible complexity and create a world and the universe and stories connected to it that I couldn't even venture going into. So we came up with the idea to go into the grain of sand and go into the very structure. I'll show you a quick video so you get a sense of it. But who created the piece? It was really the monks that created the initial art piece. But we asked them, because of the idea that we came up with, to come to Jim's lab. And so there was a very strange procession that happened one day, where we had all the artists come into this environment, but now we had center of the mandala. These pictures, by the way, these photographs are taken by Andrew Pelling, too. So this scientist is an amazing photographer. And one of the lessons we learned is they asked the monk, the scientist group, to go upstairs because the equipment was upstairs. And he said no, he wanted to do it in Jim's lab. And they said, it's fine, we've worked with very delicate material, it's not a problem to move some fans, okay? No, we're doing it here. So what happened is the microscope got moved to the monk. And we thought, okay, we really want to know what from these guys. Anyway, so here's these wonderful pictures of the monk creating the center of the mandala. And we're having discussions about nanotechnology, which took them seconds to grasp. It wasn't a problem at all. In fact, they told us, oh yes, we meditate on $1 million on top of a pin all the time. Okay. Or the number of molecules on the wall. Okay. So here is a quick, I have to change it to DVD. Sorry. Yeah, okay, so I have to just push it through. Now, can you just help me for 1 second? I need to touch it. It's working. You got it? Okay, here it is. Do you want it? Yes, I do. It's just a really cool. Anyway, I want you to get a quick sense of it. So what was created was another whole piece, right? Which is an artwork. Now, the sand mandala is envisioned to be dispersed. So after 4 weeks, 7 days a week, 8 hours, 10 hours a day of creating this mandala, the monks dispersed it in January, 3 months later, and threw it back into the ocean. We work with non-fixed technology, which I don't think is quite determined what it really means in copyright. So we turn off the projectors and it's gone. We can take the QuickTime of this movie, which took 300,000 images that we had to take photographs, and it can be reproduced so anybody can take it. So we have a question of not only who owns it, who created the artwork, but also how do we know how this work can be sold or propagated, or how do we divide those funds? Do we give percentage to the monks, and so on and so forth? So there's a lot of questions for you there. I'll move back to you.
Well, the challenges continue. Let me talk about 3 things. Mom's Mabley, the play Rent, and removing Malcolm X. Because those are the 3 cases that have defined for us the field of joint ownership. Okay, so it started off, Mom's Mabley was a famous black woman comedian. A play was written about her, but the playwright Mom's Mabley needed some help to get the play going, and so she hired an assistant, and the assistant said, great, I don't have to play. And went to the Second Circuit, and the Second Circuit said, well, you know what, it's not enough that you participate together, there has to be an intent that you both be joint authors together. Then the play Rent was put on by Jonathan Larson, and there was a dramaturg that was hired to help with the play, to iron out some of the scenes. Now, copyright law says the author owns the work. The author could be a single person, could be Mozart, or it could be 2 people like Rodgers and Hammerstein, or 3 or 4 or 5. And copyright law says that however many people there are, they own it in undivided shares. So if there are 5 people who collaborate, then each of them owns 20% of the undivided whole. And going on, that means that they don't own the business they did. It means 20% of the undivided whole means that they own the whole thing. So you have Rodgers and Hammerstein, and Rodgers is writing the words, and Hammerstein is writing the music. Rodgers can come along and say, well, I own half of the whole. I might have written only the words,
so I don't have to use it, so I'm going to license the music. In fact, I'm going to license it to Hammerstein's Worst Enemy, because I'm mad at it. And that's perfectly legitimate. And Hammerstein could also license it. He could license the words, so it's always non-exclusive. But copyright law developed to say that however many volumes there are, they each own that piece of the whole. So, John Lawrence put on the red. He had a dramaturg tell him to, as I say, iron out the details. So the dramaturg said, okay, I don't have it. Okay, that claim was also pushed back and said, look, you don't really own half of it because it wasn't intended that you were going to own half of the product. You just hired to work on specific things. Then we have Al-Muhammad, who was the Islamic technical consultant to Spike Lee in the movie Malcolm X. So he made sure that the scenes in the mosque looked real. Then he also started to add some lines in Arabic. And the people at the studio forgot to get him to sign a piece of paper. So if you ever really think about it, there are two authors of this work. One, the studio. Two, me, Al-Muhammad. And kind of said, you know, however many authors there are, they chose half, so they chose a piece of the entire whole. Your half, I'm not going to do it, your half, and I half. Okay, and that was pushed back as well, because even though we should have been compensated and we should have signed a piece of paper if they wanted to take care of the situation, they weren't about to say you don't have to. Now what do we do here? Well, we throw up our hands and say, why don't you come around these because this is a truly complex situation. In order for there to be a joint work, there has to be an additional ingredient. And this exists because, look, you can have Shakespeare's play Romeo and Juliet, and then you can have it made into West Side Story, and then you can have somebody come along and do a painting based on West Side Story, and then you can have somebody do a photograph based on painting of West Side Story. Okay, that doesn't mean that Shakespeare is the owner of together with the guy who's the photographer, and they're all one big happy family. Instead, what copyright law requires for there to be joint authors of the work is a pre-concerted design that their pieces be put together. So Shakespeare had no idea about Leonard Bernstein and Stephen Sondheim, so Shakespeare was not a joint owner with them. But on the other hand, Stephen Sondheim and Leonard Bernstein knew about each other, and they were both getting together to write West Side Story. So they had a pre-concerted intent to put their works together. So therefore, they each owned half the Empire Wall. Now I get to this situation. And the technology. So I guess I was a good guy for it, because I was a piece to say, they made, when the monks made the initial mandala, did they design it as an integrated whole, or did they design it with the idea that this is going to be part of the nanotechnology exhibit, and therefore is going to be put in to wrap up with nanotechnology?
But I hate to tell you this, but it's more complicated. Commissioned the monks to do the mandala. We were curious to see how the mandala looked, but they said, we don't really know, because it happens in meditation, and it changes, which actually happens with every artist. You change things as you're in the process. So then when the monks came to the lab, we gave them an offering, right, in the way we were paying them in a different kind of exchange. And they participated wholeheartedly in the process. They really, really liked this other manifestation that's equally transitory to what they were doing. So that's another whole layer. But they very much participated. We, on both sides, had no idea where we were really going with it. So it was very much a kind of an organic process that's developed.
Okay, well, I guess the way I would come at this situation would be to say, well, now, before I even get there, I need to now add an additional layer of moral complexity. Okay, there's one dispute in the law, which is, what does it take to be a joint author? To be an author, as I said, you have to create a work that's fixed in a tangible medium of expression. But now the further question arises, to be a joint author, what if you have one guy who's the great idea man and says, yeah, you know what, let's put them in a sitcom, blah, blah, blah. And another person who's a genius in kind of, putting it, writing it down and fleshing it out, But person number 2 doesn't have any kind of creativity. So that might be a very useful collaboration. So the question becomes, are they both joint authors? Well, starting way back, it's always been the position of Nimmer on copyright that yes, that is a form of joint authorship. When you get 2 people together, one's good here and one's good there, and they're combining to write a sitcom or a novel or create a sculpture, that's fine. They're both joint authors. Starting around 1990, the courts confronted that and said this is very difficult, but we think no. An author is someone who creates a work in a tangible medium of expression, and therefore a joint author has to be someone who creates a work in a tangible medium of expression. So the idea man, as valuable as the contribution was, gets nothing. He's a non-entity. It's only the people who contribute expression who can be joint authors. And from 1990 till 2004, there must have been 20 cases that held to that effect. So I would have told you that that's the answer on this particular wrinkle, but 2 months ago, things changed. Judge Posner, who's one of the most respected judges in the country, said, you know what, that Nimmer test really had more to it than we thought about. And in the software context, when someone comes up with an idea that might be the most valuable part of the software functioning, even though they're not the coder, you really should give credit to the idea person. So that's a new trend in the law. So I'd say just about everything is up for grabs here. The people who have the ideas are either joint authors or they're not. They either own it with the monks or they don't. Either the monks own it equally with you or not. And maybe the museum owns it. But let me ask you this. I'll just ask one more question about the monks, about the museum. Because actually, I do work for the Getty from time to time, which is just the most fabulous client because, for instance, one time they had a program to preserve works of art. And they said, you know, this is being copied. And we're very upset about it. I said, oh, I can understand you're upset about it. I said, no, we don't know it's being copied. We want everyone to copy it. But they're charging money for it. We made this to be free to everyone. Stop them from charging money for it. So in any event, the issue often comes up in the museum context. Let me ask you the following. The monks, I presume we can say, were not employees of the museum. They didn't work there for 52 weeks and get 4 weeks vacation and Social Security benefits. Like they were employees. Did they sign a piece of paper saying this is a specially commissioned work for hire? My guess is no, but you tell me.
I have a feeling they must have signed some kind of contract where they're saying they're going to come and do this piece for the museum. But you have to remember that last for 3 months and then was dispersed and went off into the ocean. So what this is us coming to the museum when the piece was finished with a crane and a camera. And Jay, who's a student working with us and us standing there directing it, did about 300,000 still photographs that then were created into the movie that exists. In other words, the piece itself is in the ocean. It's gone.
Right.
So it's really the software, which is off-the-shelf software. So the software is no problem. It's macromedia. It's not custom-made. The idea are the only people who remain, the idea people. And I mean, there's nothing, don't get me wrong, nothing would make me happier than some museum saying, we'll give you a lot of money for this, and we contribute to the monks and to the university and live happily ever after. It would be great. It's not about that. It's more about addressing this idea of tangibility and fixed nature as defining what the art is. And I'm very happy to hear that the idea of concepts and ideas being valuable is coming back into the picture, because that's ultimately what each one of these cases was about.
You know, I read an article in 1996 that I called Brains and Other Paraphernalia of the Digital Age, which I posited the following, that there was a great poem called Ruthless Boaz, and every copy of it was destroyed. And then I asked the question, is Ruthless Boaz still protected by copyright? Although yours is a much better situation, because it's a mandala and it's created by monks. But in any event, this particular case is easy because it is fixed and intangible medium of expression as proven by the fact that we all just saw it. My article tried to probe in the more conceptual realm, which is what if there's someone who has perfect recall? Is a brain a medium of expression? And Japanese copyright law, for instance, does not require a tangible medium of expression. It recognizes oral creations. So I was trying to harmonize U.S. law and Japanese law by saying, well, it is fixed, because you know what? Just like the dynamic RAM keeps the work there, and you can reproduce it 20 minutes later. Okay, so the brain is the same thing. It's there until the person dies. It was a thought piece, but it's a wonderful question you have here. I think you clearly do have, through your photographic work, you have continuing copyright protection for the pictorial work that was created, the mandala, meaning that if some other museum wanted to create it for whatever reason, exactly that particular arrangement of shapes, you could stop them. Or someone could stop them if we figured out who the copyright owner was. But of course, that's not the goal here. So I guess in terms of the practical issues, in terms of being hung up on legal ramifications, we don't really have anything hanging us up here. We'd be happy to have another museum come and hire you, the monks, or to hire rival monks and rival artists.
Two quick points. One, I'm heartbroken that most didn't sign an intellectual property agreement. Secondly, a question now, a more interesting question perhaps. Is a ephemeral image in electronic medium, whether it's on an LCD, whether it's projected as a hologram, whether it's whatever the technology becomes 50 years from now, is that image copyrightable, or is it the tangible form of that in the memory of the computer that's holding that image?
You called it an ephemeral image, but it still is held in memory. So therefore, I'd say it's not ephemeral. The truer question would be, let's say if you can imagine a website that is interactive with 100,000 users, and it's creating a painting right here, but it's created based on the input of all these people throughout the world, and for whatever reason we don't have a video camera running and we're not recording it in RAM or on the hard drive. If that were the case, then it would not be fixed in tangible medium of expression, so it would not be, that image would not be copyrightable. But there's an easy way around it, which is to set up a video camera, and then you could claim, well, you'd have an audiovisual work, and the audiovisual work would be portraying that movement on the screen, and so you could achieve copyright protection in that form.
But if you save it from RAM onto a disk or into a hard disk or disposable disk, that would give you a tangible expression.
Right.
What I'm trying to get at is that a lot of people create digital art. When does it become a tangible item that is copyrightable? Does it require printing? If all you ever did was show it on a screen in the computer that it was created, but you never saved it or you never printed it, is that copyrightable?
The key phrase is a period of transitory duration. It has to be there, whether there is, longer than a period of transitory duration, which led me in my fanciful way to wonder, well, a brain could keep it for longer than a period of transitory duration, but no code would ever go along with that. So, for instance, writing in frost on a window pane might be a good example of something that is probably not there for more than a period of transitory duration. Or my other example, and these are the only two I can think of, maybe you'll give me a third one. My other example is writing in the sand in front of the oncoming tide. It's not really there for any longer than a heartbeat or 2 or 3, maybe 5 or 6 if you're lucky, but you cannot, with any reliability, plan on it being there. If you record it in any form, electronic, optical, paper and pen, however, that you can come back after a period of more than transitory duration, and it's still there, that's all you need for fixation. So therefore, this mandala certainly was fixed. Somebody could be very creative and say, there's a doctrine called estoppel, namely, hey, you destroyed the only copy. That must mean you did not intend to preserve your rights in this work of art, which might be more than a frivolous contention here. There have been one or two cases. It was about the TV stations in the South that were recording things and then erasing it because they didn't have that much videotape in the 1980s. So maybe this would be the second case. It's possible. Yes, we're going to give him the microphone.
So much of media art and film art is very nature, and experiential to some degree. The idea of fixation of an ephemeral experiential experience is a problem. And yet, walls like fixed glass, are things to be paid. And so it would be an argument that is in essence experiential. What sort of remedy does it have in law of protection? And then the second question is to comment on primitive property. There was a thing called creative commons, which is sort of the evolution of
the second question is about the Creative Commons, which is a group of people who are getting together voluntarily to abjure copyright protection and say, look, we want this to be available, and it could be on various terms. You can reproduce it, but you always have to put my name on there. You can make as many copies as you want, but only for classroom use. As long as people want to go along with it, I think that's a fantastic idea. It's very new, so we'll see if it's simply an epiphenomenon that disappears or whether it gains wide-scale acceptance. But there's nothing wrong with copyright owners trying to come up with new Creative Commons. It's a Creative Commons. It's exactly what it purports to be. Now, your first question is, what about experiential works? How does the law protect them? And I guess the summation of where we've headed thus far is, if it's strictly experiential, then there is no copyright protection for it because it's not that fixed in that tangible medium of expression for a period of more than transitory duration, which brings us back to that teaser on the video game. That's what it was that made this protectable. So in almost any sphere, you can come up with your own analog to that teaser to fix a part of it and then have the user off on their own experience.
But the experience is fixed on a roller coaster ride. Well, it's a virtual reality game that allows you to fly. I mean, it's exactly the same experience for anyone who gets on that ride. And doesn't that offer something?
Well, no. The simple answer is the roller coaster ride is not copyrightable. And it's probably not patentable, so yeah, anyone can build a roller coaster. You could say it's a sculpture work, but unfortunately, copyright does not apply to useful articles. And so the flourishes on the roller coaster might be copyrightable, but not anything that's useful in terms of making the roller coaster run. So probably the roller coaster ride and the experiential art, it's too avant-garde, and the law has not caught up with that. So, yeah, I'm sorry, we're out of luck on that one.
Very interesting.
Are you going to do more? Okay.
Well, the very interesting thing going on in theater, film, and television here, where combining senses with performance sound allows you to map an experience. I mean, you can map and record how people move in a performance, and then that could, in essence, be put into a tangible medium and preserved. So some experiential activities, at least, while the experience appears to most to be fluid and ephemeral, one could actually record it in a format other than photographically.
Well, there's Leban notation, which goes back many decades to record choreography, which is a very protected means before the advent of videotape. You write notation about all the places that the dancers move their hands and their legs and their bodies. So in theory, that could apply to anything. Now, an example that this brings to mind, which I'll get to on page 220 in my treatment of the Dead Sea Scrolls, is the following. There could be a play on Broadway in which the choreographer has, let's say, a man and a woman are both shopping, they both run into each other with packages, and they go like this, and they try to pass each other. And that could be very highly scripted with Leban notation or on videotape.
And I say that's copyrightable as long as it had, let's say if it lasted for 45 seconds, and it was more than simply, it was more than what I did there since I'm not much of an actor. I'd say that could be copyrightable. On the other hand, you could walk down Madison Avenue in December, and you'd probably see 100 reenactments of things that are just like that, but are also taking 30 seconds. Does that mean that each of those is copyrightable? Okay, my answer is no. Each of those is like the baseball game, to revert to where I began. Those people are not trying to create a work with a tangible meaning expression. They're trying to hit a fly ball, walk into Burger Goodman, get to the subway, whatever it is they're trying to do. So based on a very elaborate analysis of the Dead Sea Scrolls and 100 other things, I concluded in that article that some type of intentionality underlies copyright. There has to be an intention to create an artwork. Now, if you disagree with me, you're a good company, because all the other commentators say that's ridiculous, and we'll come up with 100 different examples. But I'm not saying what I said anyway, because it's a useful prism in which to gauge copyright. And I also happen to think, I still happen to think it's right, even though everyone disagrees with me. So don't consider that as dogmatic, but just consider it as a way of thinking. So it's a wonderful example that gets us back to yourselves, which is why I was trying to, I don't need to cross-examine Andrew at greater length to try to figure out what was the intent behind there. So I'm going to try to tell us a little bit more. You're an artist. Tell us about the artistry of that project, because I'd like to know about your intentionality.
The manila.
I'm not going to lie. We'll go back to the music that comes from the cell.
The cell. Well, actually, I have to say that that particular piece was much more Jim's intention.
Ah, okay. So that
also makes it more interesting in this context because what I said earlier, suddenly the data that he was creating in his lab was perceived differently by him just by his interacting with artists who would look at that as a creative process. And so the intent shifted on his part because he started looking at his data in a different way.
I think you're doing more art therapy than art therapy. Because I don't know in your own mind think that you're creating art. It's rather you having an effect on a scientist and, helping bring the art of the United States.
That's actually the role that I think I've played in the UCLA science world. We're expanding the vision and making the kind of daily boring work exciting because we're giving it more of a reason why it exists. Everyone is said to me by the scientists themselves.
Let me ask you this. If you were nominated for a presidential medal of art, and you could only put one representative piece forward, I'm going to guess that there's no way you would choose among today's selections the cell music. Am I right?
You are right, but it could be. I actually neglected to show another piece that I showed and asked Jim to specifically do a composition.
We have a few more minutes if you want to get into it.
I'm going to try to find it, but I was invited to do an exhibition in Korea while we were doing nano, and so I was just assuming I would just do one of the pieces from nano, but it turns out that this was in a prison in Korea, and so I realized, well, this doesn't really go with nano at all, and I have to think of another use for a software that we actually did develop. So I thought about the context, which was this prison in Korea. Unfortunately, I don't have a really good image, but you have to kind of imagine it a little bit. So I'll just pull it up this way. These are the prison cells. So what I thought of, again, very much conceptually, but giant sounds that are of cells. I took the projection that you see here, and I kind of created a very short poem about the prisons of our mind and about these cells, and then projected outside of the cells. I asked Jim, can you please torture some cells for me? He was also delighted to do that. heard this excruciating sound, which you just experienced variations of. So it's very much a conceptual piece, and I feel really proud of that use of it, because there was this kind of connection to the sounds, to the concept of it, to the space that was done very much remotely, and thinking about the idea of cells in the present, and so on and so forth. So that's an example of how I worked with sounds of the cells.
Right, okay. And the central conceit seems to be cell versus cell.
Yes.
Right. So if you remember, in their period, that insight can deserve room notoriety, but I don't think it's copyrightable. So I don't think anyone else can copy that. But we talk about performance art, and it's interesting because in some sense, and experientialize, really, the question there. In some sense it's brand new, and in some sense it isn't. I was amazed that just a few weeks ago I was reading a case from, I think it was 1899, and he talked about tableau vivant, which is like in the Nimmer pageant of the Masters, when everybody comes together and they act out like an old Dutch masterpiece. And just a conceptual question, what's the copyright status of this? Now, the judge just mentioned that in passing. It's just a kind of curious thing that we didn't know how to solve. And I guess that's where we're at wrong, that we have a very hard time solving the issues that are posed by these things that push the boundaries.
But I'm glad you brought this up, because to me, what Anne and Andrew did posed all issues. It didn't matter to me. But to the end it did. You see, I felt that what they were doing was their own work. In other words, they were creating a work that was their concept using the research that was being done in the lab. What I could see when I talked to Jim about it, and this is where I actually agree with your comment, I thought, okay, well, then they should have taken their own cells and done research and used them for the music in order to avoid the scientists saying, well, you're using my work, right? So, because he wasn't brought in as a collaborator, there was a tension that was created. And to avoid that, in my opinion, you would either have to do research on your own cells and produce something. So it is derivative to a degree, but you are doing your own thing, or bring the person as a collaborator. But there's no question in my mind that what they did was original as a piece. So it's very confusing in some ways.
When I talk about the film company, I want to ask him, why did the film company want to license it? And I have a spectrum here. On the one hand, they want Paul McCartney's song, and they don't want to say it, but they want that song, and so therefore they're going to pay Paul McCartney. On the other hand, there's just some weird process that the filmmaker doesn't know how to do, and he knows you know how to do it, so he's going to pay for it. Then I guess it's that second half of the spectrum that's involved here, but you tell me.
That's it, but yeah, it's just hot right now, everybody wants it, and,
So they can't tell more in special effects, or they're going to get sound noise.
Probably, yeah, but Jim talked about that, and it's just simpler just to have them somewhere else and to go through all the business of who gets what and legal stuff like that.
Right.
Yeah. But can I make a comment? Yeah, I totally agree with what Victoria said about a lot of things about intention and things like that, and at the end of the day, I think I've got a lot more to do with my life than sound sounds. But at the end of the day, it comes back to a point that you raised that I don't think got really discussed, probably because there's not many graduate students here. But it's the idea of the idea man and the worker, and sometimes those roles change, and often they do in the academic environment, where the student will come up with an idea, initiate a project, and I've done this, and obviously, I'm not saying I think we're right, Jim, and obviously not, but still, that issue still comes up. And it was interesting, this month, in American Physical Society, they release a monthly newsletter, and this month they dealt with ethics. And one of the main topics was, where do you assign credits to graduate students, postdocs, and professors and in the university, and where does that all play out? And it's almost taken for granted that, you know, no one will actually say it, but the graduate students are the lower rung monkey, do the work, get no credit, and then, you know, you earn your way up the ladder, and then you're a professor and you can do it to your students.
Yeah, right.
So, I mean, it kind of goes into, like, Ginny ever told me, I want to make a cell piece, right? So where does that, you know, where do all these ideas come in and things like that?
Well, I'd say it's a useful comment to end on, because let's compare UCLA and Walt Disney Animation. Okay. In some sense, they're both producing a product that might have commercial value. Every single person at Walt Disney Animation, when they start their job, has to sign a piece of paper that's been thought about by the lawyers in advance. And so there's no doubt at the end of the day, when the movie Aladdin is made, that it's owned by this corporate entity and that none of the individuals has a right in it. Okay, at UCLA, it's probably not the exact opposite, but almost the exact opposite. Maybe 3 people out of 1,000 have thought about it in advance, gone to a lawyer and signed something. And the other 997 are all there like a bunch of atoms and, you know, and bumping against each other. So by the time it comes ripe to exploit the work, all you have is an absolute nightmare. And it's much cheaper to simply shelve it and reconceptualize and begin anew than to try to work out, you know, let's call it the months in Tibet, you know, and the girl graduate student now hates me, and, you know, and the guy that I turned down his 10 application, and, you know, let's get it all together, and, you know, then we'll be able to market it. So, now, what's the solution? Well, you know, lawyers can always say the solution is to lower everything to death. That's not necessarily the best solution. It might, you know, it might be killing the goose that lays the golden egg. It might not be necessary in 98 cases out of 100. If your goal is to get yourself to a place where you can market those 2 products out of 100, then I'd say, you know, sit down in advance, work it out, talk to the Office of Intellectual Property, and if you're still talking among yourselves after you leave the office, you know, then you have some hope of working it out. And if it doesn't work out, then you're just in the realm that you've always been in for the last, you know, since the University of Bologna was established in 1302, and I guess we can continue on from there. Okay, thank you very much.